Right. That's what I'm thinking. All rise. Hearing recorded for the county is now in session. The Honorable Chief Judge, you're glad you're presiding. Come Lord.
Good morning, ladies and gentlemen. Please proceed.
Everybody's President California. Everybody's President California.
Heard in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Go ahead and take roll for the morning. Mr. Beebe and Mr. Partridge, good morning, gentlemen.
Good morning, Judge.
Mr. Stillwell, Mr. Boston, Mr. Sharp, good morning, gentlemen.
Good morning, Judge.
Mr. Williams, Mr. Steele, Mr. Adams, good morning, gentlemen. Mr. Mender, Ms. Fagan, good morning.
Good morning.
Mr. Kenrick and let's see, Ms. Hingerty, good morning. Mr. Ewing, Mr. Matthews, good morning, sir.
Good morning, Judge.
Mr. Myrick and Ms. Bernard, good morning. All right, Mr. Nichols and Ms. Westmoreland, good morning, madam. Mr. Adams and Ms. Callum, good morning. Mr. Blaylock and Mr. Hill, good morning. Mr. Dorsey and Mr. Jimenez, good morning, gentlemen. Mr. Ebinger and Mr. Johnson, good morning, gentlemen. And Mr. Ryan and Mr. Williams, good morning. Okay, good morning, Ms. Love and Ms. Hilton and Ms. Weiner. Good morning. Weintraub, I should say. Good morning.
Good morning, Your Honor.
Oh, and welcome back, Ms. Von Kelsch.
Good morning.
And good morning, Mr. Randolph.
Good morning, Your Honor.
All right. Do we have Dr. Nielsen outside?
Correct.
Can we go ahead and recall him, please? All right. Yes, you may, sir.
Your Honor, we have copies for counsel of the two requested questionnaires. That's for juror 1089. Mr. Steele said he did not have that, and 1157.
Okay. At the first break, counsels, you are welcome. Ms. Von Kelsch, if you would go ahead and hand those out along with Mr. Randolph, that'd be great. Okay? All right. You don't look like our witness.
Good morning, Judge.
Good morning.
Joshua Schiffer, here on behalf of Director Ali from the Georgia Public Defender Standards Council. We entered an appearance this morning regarding a motion to quash on the subpoena brought by Ms. Williams, and at a break, if Your Honor has anything to discuss.
I don't believe that we're hearing that until the 1st of May.
Yes, Judge, and I believe that was the date where Director Ali has been summoned to court for the subpoena.
She'll have to come for that date, and we can argue your motion at that time.
And it's unavailable for us to be heard on the quash. She has other items.
No, ma'am. No, sir. She's going to have to show up on that day. You can tell her you asked, but that's the day I set. She doesn't have any other special authorities or otherwise, so she's going to have to show up at that date and time.
Thank you, Judge.
Okay, but yes, but I appreciate you coming by, and good to see you, Mr. Schiffer, as always. That's right. You are so correct about that, okay? All right, we'll see you on Monday, okay? All right, sir. All right, Dr. Nielsen, go ahead and retake the stand. I'll just remind you, you're still under oath, okay?
Yes, sir.
All right, thank you, sir. Make yourself comfortable, pull your chair up as close to the microphone so we can all hear you.
And may I remove my mask?
You can, sir.
Okay.
Yes, sir, if you feel so that you'd like to.
May I begin, Your Honor?
Yes, you may.
Thank you, Your Honor. And good morning, sir. How are you?
Good morning. Hanging in there. Thank you.
Good. Did you have a restful evening?
Ish?
Ish.
Yeah.
All right. Well, I hope that your day goes well.
Thank you. You too.
Did you talk to Dr. Dunbar in any way after he testified before this honorable court?
I don't talk to him No. Oh, I did reach out to him because I asked him if he wanted to talk. We haven't spoken yet, but I did reach out because I wanted to talk to him about collaborating on future research. There are a couple of studies that I was hoping he could help me, that he could design and that we could work on together, but we have not yet spoken. So no, I have not spoken with him since his testimony, no.
And did you in any way text about his testimony?
The only thing I think I texted to him was that I was sorry that the first time he came out, he was not able to actually take the stand. That's all I think that's all I would have written to him.
And of course, that's after the first time he wasn't able to take the stand. What I'm asking about is after he testified.
No, he may have. Yeah, no, I did. I think we did text once because I am working on a documentary and related to this issue. And in addition, someone else had reached out to me about potentially serving as an expert, and I wasn't able to do it, so I referred Dr. Dunbar to those attorneys, and I asked the producers of the documentary I just mentioned to reach out to him as well, and then he texted me and said, "Thank you very much for keeping my name out there," or something like that, but nothing beyond that.
Okay. Now, did you watch Dr. Dunbar's hearing on YouTube, the news, anywhere like that?
No.
Okay. So as it stands, is it your testimony that you have not in any way been exposed to Dr. Dunbar's testimony?
No, yes, that is, I have not. I just am aware of his that he testified, but that's all I know.
Okay. I want to talk with you just a little bit about your resume, your CV.
Okay.
All right.
And would it be possible for me to have a copy of that?
It would, in fact. I believe that it's already been admitted. With court's permission, I'll get what has been admitted.
What's he asking for?
The CV.
Yes, it's already been admitted as Williams 7. Say again?
We can't hear back here.
Okay, she asked about the CV in terms of, and I said it was Williams 7. It's been admitted already.
Said we, it may be dismissed.
I'll speak a little bit louder, Your Honor. Make sure
Yeah, you
everyone
can speak
can
in the
hear.
microphone too, madam. That would be great.
Yes, Your Honor. Thank you. If you would, I'd like for you to clarify a couple of things.
Actually, ma'am, I want to
Yes, sir.
backtrack something. I do think I read something about Dr. Dunbar's testimony. It was in the news or something that maybe had something to do with, I just don't remember. It was that he testified. That's all that I remember, but I want to be as candid as I can. I did see in the news that he testified, so I just want to be clear about that.
And that's fine. Thank you for your candor. So you're telling the court that though you may have heard something on the news, the substance of which you can't remember,
Yeah.
you did not speak with or confer with Dr. Dunbar or anyone else about the substance of his testimony?
Correct.
Okay. Thank you. Looking at your CV that is labeled Defense Exhibit 7 that you have in front of you, I would like for you to turn to the legal experience section. And if you would, I'd like for you to clarify a couple of things for me.
Okay.
You mentioned under the legal experience section the amicus briefs that you authored, correct?
Yes. Co-authored.
Okay, co-authored. Now, you had already mentioned those earlier on this CV under the miscellaneous section,
Yes.
correct? But you thought or felt like they were worth listing again under the legal experience section?
I guess, yeah.
Is there any reason you listed it twice?
I could sit here all night, but I'm going to object to relevance.
Yeah, what's the relevance, madam?
Your Honor, I'm specifically getting into the witness's qualifications as an expert. And if the court would permit me, I will follow up with more questions because, as the court is aware, that the defendant bears the burden of proving that his witness is qualified by knowledge, skill, experience, etc. And his resume is a piece of evidence that Mr. Steele has tendered that I, as the...
But we don't need to go into all of this, Ms. Love, at this point in time in terms of, I mean, for my gatekeeping function, it's kind of limited. Some of the stuff I let you get into yesterday is related more toward, you know, weight versus anything else. So if we could kind of, you know, kind of get to more, I would say more substantial substantive issues, but fly speck in his resume is not going to help me.
Judge, I appreciate the court's position, and I will, of course, adhere to the court's instruction. The reason that I'm asking Dr. Nielsen about the things that I'm asking him on his resume is that I am attempting to elicit testimony regarding the extent of his qualifications for certain testimony that Mr. Steele has represented that he will be proffering. And of course, looking at the 702 analysis of whether or not a person should be qualified under Daubert, looking at whether or not his testimony is based on sufficient facts or data, is a product of reliable principles and methods, and whether he's applied those principles and methods reliably to the facts of this case are what, of course, the court knows that it looks at in performing its gatekeeping functions. So I will not belabor points that I ask about.
And you and the resume is in evidence at this point in time for consideration.
Correct, Your Honor.
Okay.
Correct. But the information that I'm inquiring about isn't on there, and so rather than say specific parts of the resume, I'll just ask about the parts that I'm inquiring further into.
Okay.
Okay. Dr. Nielsen, when you refer to legal experience, have you had any actual legal experience?
I'm not sure how you would be defining it. If this would be an example for, I would consider this legal experience. I'm in a courtroom testifying.
Okay. You consider sitting here now as legal experience?
Asked and answered.
Sustained.
Clarifying, Your Honor, I did not hear what he said.
Asked and answered.
Still asked and answered. Still asked and answered. Come on, let's move on.
Okay. So, for legal experience, it doesn't involve legal work, but it just, what?
Asked and answered.
Your Honor, we have to get into what legal experience, or what he means by legal experience, considering it's something that he has on his resume and part of the qualifications Mr. Steele is putting forward to the court. So, of course, the state is entitled to thorough and sifting cross-examination of this witness who is being tendered as an expert, that Mr. Steele is asking the court to be allowed to offer his opinions to the jury on a particular area. So I'm trying to ascertain, when he says legal experience, exactly what he means by legal experience. That's it. And I'd like the court to have that information as well in performing its gatekeeping functions. The court could decide that what he has listed as legal experience isn't, or what he thinks is legal experience isn't, or what he defines as legal experience is not.
It's going to go to weight. I mean, I think that his experience that he's testified to is unless there's some specific issues that go along with the problems under 702 in my gatekeeping function, I think you just need to move on.
Yes, Your Honor. Now, speaking of your qualifications to testify as an expert in a criminal case, you've not gone to law school, right?
No.
And you've not taken any legal courses, right? Or am I wrong?
No, you're correct.
Okay. And you'd agree with me that witnesses that testify in court every day don't necessarily have legal experience?
I don't know how you're defining. I'm defining legal experience exactly how it's here.
I'm just objecting to relevance. I mean, what difference does it make that everyone knows witnesses who testify?
Yeah, I'm going to sustain the objection.
Thank you, Your Honor.
All right.
And when you testified once before in Georgia, and correct me if I'm wrong, have you testified any other times in the state of Georgia?
I have not.
That was in the Bradford case, correct?
Yes.
And that was before Judge Craig Schwall?
I believe that's right.
And that testimony was in 2015, correct?
That sounds about right.
All right. Now, the testimony that you gave in the Bradford case that you've listed and talked about on direct examination, that testimony was given before July 1st, 2022, right?
Yes.
And before the Daubert standard was the standard for determining whether or not a person would be admitted as an expert in court in Georgia, right?
In Georgia, yes.
Right? Okay. So briefly, since you talked on direct about your testimony or having given testimony in the Bradford case, you'd agree with me that how you were qualified or what you were qualified as in the Bradford case would be relevant for the court to examine your abilities or expertise, as you've put it forth, correct?
That's for the court to
That's
decide.
mine to determine, Ms. Love.
Thank you, Judge.
I mean, you can trade places with me if you want.
I do not want your job, Judge. Thank you,
You know, and
so
you can-
much. I'd prefer to stay
You can
right
certainly-
here.
You can certainly go through this exercise, ma'am.
I'm good. Thank you, Judge.
All right.
And in the Bradford case, you testified under oath as a proffered expert that you had been focusing, I'm using your words, you had been focusing on the prosecutor's use of rap music, unlike other fictional genres, to convict defendants nationwide. Do you remember stating that?
I don't remember. I think it was 8 years ago. I don't remember, but I assume that I did say that if you're reading it.
Okay, you don't have to assume. I can show you a transcript of your testimony if it would refresh your recollection. Do you think it's possible that it might?
Well, I'm sure reading it would help with that, but what you've just stated does sound consistent with what I would have said, so I don't feel like I need to see it right now.
Okay. So you do remember, just to be clear so the record is clear, you said it sounds like it's something consistent with what you would have said. I'm going to go ahead and show you page 3299, and if the Honorable Mr. Steele would like to see what I'm showing you, I'll give you a copy of it. And I'm going to show you a paragraph on page 3299 and ask if it would help you to actually remember what you said. May I approach, Your Honor?
You may.
Thank you. All right, if you would just go ahead and read on page 3299. Starting at line 18, going to line 22.
Okay?
To yourself, not loud.
I understand.
And let me know if it refreshes your recollection as to whether or not you testified in that manner to those words.
Yes?
Yes, it refreshes your memory?
Yes, it refreshes my memory.
Okay, and yes, you testified to those words, correct?
I assume, I mean, I don't remember, but yes, if that's what it says there, then I did.
And when you told the court, when you told the Honorable Judge Schwall then that you had been focusing on, let me back up just a moment. you do not remember what it was that you were tendered as an expert in, do you? Or do you?
I don't.
Okay. If Your Honor would afford me one moment, I am
Yes,
pulling up a
ma'am.
particular page.
3302.
Will, I appreciate that from Mr. Steele, Your Honor, but there is a particular, I have that page marked. There is something other than that that I'm looking for. Thank you. And thank you, Mr. Steele. I appreciate you. You testified in that case as well, or rather you were asked in that case how many cases involving rap music and rap lyrics that you have been involved in, correct?
Again, I don't recall, but that sounds like something I would have been asked.
And you were asked a question about whether or not a defendant in that case is a member of a gang based on the content of his music, correct?
I don't recall.
Okay. You were asked in that case to, and I'm quoting, and if you don't recall this, let me know so that I can see if we can refresh your recollection. You were asked, can you explain the use of rap lyrics in criminal trials? Do you recall being asked that question?
I don't.
All right, in just a moment, I'm going to bring this up to you. And so if you don't recall being asked that question, do you recall ever speaking to that question, answering it?
In that particular trial?
Yes.
No, but I'm sure I did. It's 8 years ago.
Okay, so I'm going to show you, but Your Honor, out of respect for counsel who's standing up behind me, I'm going to let the court inquire whether Mr. Steele has something to say since he's standing while I'm inquiring of the witness.
Sir, do you have an objection?
Yes, sir.
What is your objection? What's the basis?
Beyond the scope of this hearing under Daubert, doesn't matter what he testified to about opinions. The opinions go later. This is about qualification.
Your Honor, I have a direct response to that objection, if the court permits.
What's your response?
Judge, when the court is assessing this witness's credibility as an expert in the area that he is being proffered in, and when this witness on direct examination spoke more than once about being tendered as an expert and speaking as an expert in a particular criminal case, the only one he's testified in Georgia, he makes very relevant and necessary for the court to learn the extent of what he offered or what he was willing to say and do in that case in order that the court may determine whether or not he is credible as an expert, qualified by knowledge, skill, experience, training, or education to testify about the matters that he was and is being proffered to testify about. And one of the questions I'll be following up with is exactly what he was qualified as an expert in. It's very similar to what he is asking now. It's exactly like it, I think. and there are points that need to be made. I'd ask for a little leeway. I will not belabor the point.
Madam, I'm inclined to sustain Mr. Steele's objection. A couple things. One, this is, pre-Daubert and July of 2022 in regards when the legislature changed. And then also, I believe that it goes to weight more than anything else. I mean,
Your Honor, yes, it does. What I'm getting at is that if, as an expert in any trial, I'm using this as an example, in no way suggesting this witness did this, but if Your Honor could imagine that someone is tendered as an expert in fruits, and as an expert in fruit, that person gets up and is asked an opinion about cars and trucks and televisions. And the expert is aware he's supposed to be talking about fruit, but he all too willingly gives his opinions about cars and trucks and televisions.
It would be objectionable.
Right, exactly.
Okay,
but
so
it would also speak to the witness's, not just his credibility, but his actual level of expertise and whether or not he is the kind of expert that Daubert anticipates, and whether or not his expertise is based on studies, research, and measures as Daubert anticipates, and asks the court as a gatekeeper to evaluate whether it's based on reliable data. So if he testified and he specifically made assertions about things that he is not qualified to talk about, but held himself out as an expert in, I think that it is, you're right, it goes to the weight, but the court has to make an initial determination, not about what he's talking about at trial, but you have to decide his admissibility as an expert. And if does not the court think that what he's willing to testify to and what he's willing to do, just as a juror would judge the credibility of a witness, when the court is deciding whether or not to admit an expert, that's an even more heightened examination. Should not the court be privy to the things that he has done as an expert?
well, it goes to weight, again, it goes to weight. I mean, if somebody testifies about, using your example, fruit, and they conflate it with cars, well then, jury's going to decide, well, hey, what are you talking about? And they're going to make those two assessments based on that. But
Right.
if he's been qualified already as an expert, and also remember, the law's changed in regards to what it was pre-22 to now. So part of this, if you could just focus on, on the things
Absolutely.
that I have to decide on my gate. This really is kind of way beyond this. Almost a standard.
Absolutely, Your Honor.
Okay.
Thank you.
All right.
And so, Your Honor, I would just proffer that the fact that, as the court has pointed out, that prior testimony was pre-Daubert, the court should let it in no way factor into the court's decision.
I don't know anything about it. I don't.
Right. The fact that he did
at this point,
testify.
remember, qualified to testify about the matters he intends to address, the methodology in which the expert reaches his conclusion is sufficiently reliable as determined by sort of inquiry mandated by Daubert, and the testimony assists the trier of fact through the application of scientific, technical, specialized expertise to understand the evidence or to determine a fact. Okay, so that's that's what I have to kind of resolve in terms of my my gatekeeping function. So and Mr. Steele did in fact cite a Supreme Court case a couple days ago in regards to Nundra versus the state, which kind of gives me some of the factors, but it's not an exhaustive list, but it gives me some of the things that I have to kind of go through. So to the extent that you can kind of focus on those, that would be great.
Ron. Focusing on your tendered or proffered area of expertise, am I correct in saying it's African American culture, literature, history, and music broadly?
I think it's popular culture, but yeah, that sounds right.
Is that a yes?
That would be a no then, because what you said is not what I said.
Okay. So you are not an expert in African-American culture, literature, history, and music?
No, I am an expert in African-American literature, popular culture, music. I'm putting the word popular in front because I do not present myself as an expert in African-American culture.
We're not going to talk about Bradford anymore, but have you ever tendered yourself or offered yourself as an expert in African-American culture?
I have not. I mean, the attorneys typically write those descriptions and submit them. Sometimes I look at them, sometimes I don't.
But if you're hearing, you would or should, as in this case, if you heard a description of an area that you are not an expert in, would you be willing to clarify it for the judge and the jury so that we know what it is you expect to be talking about?
I certainly wouldn't testify to something that I was not qualified to testify to.
You have an objection, sir?
It's going to be the same objection, beyond the scope of this hearing today. She's asking, Ms. Love is asking questions about hypotheticals of what Dr. Nielsen would testify to if somebody tried to qualify him as an expert in a field he's not in.
Got to be qualified first in order to give an opinion, but it does go to his qualifications, Mr. Steele, since that's in your 702 notice. And if she's going to walk that particular notice, just like you did yesterday, I think that she's entitled to do that. So I'll overrule that.
And I won't have any objections to that. That's really not.
Okay. I will sustain as to form of the question. Go ahead and rephrase that, Ms. Love, if you'd like to.
Yes, Your Honor. And Judge, just as a matter of record, since that hearing, that testimony that this witness testified about on direct examination as a part of the Fulton County Superior Court record, I would ask that...
Well, go ahead. I'm sorry. Go ahead and finish your question. I apologize.
I would ask, since I'm not going to get more into it, I would ask that the court just take judicial notice of that transcript in that case. 13 SC 123643, page 3302.
Is it in Odyssey?
It is, Judge.
If it's filed in Odyssey,
It is.
I can take judicial notice of it.
Thank you so much, Judge.
What did you say it was in 13 what?
13 SC 123643, specifically page 3302, where this witness held himself out as an expert in African American culture, literature, history, and music.
Okay.
Thank you, Judge.
Okay.
All right, I'll move forward. Now, you know that we received a notice of expert testimony from the Honorable Mr. Steele here, correct?
Yes.
And you know that in it, Mr. Steele summarized your testimony, right?
I believe so.
Okay. And are you aware that in it, Mr. Steele says that, in summary, your testimony will be that there are, quote, loads of empirical research on the racial aspect of rap music's impact on listeners?
Yes, that sounds correct.
Okay. And do you then agree with that summarization? There are loads of empirical research on the racial aspect of rap music's impact on listeners?
Yeah, there are a number of studies.
And because we do have to determine whether or not or the court does, I don't, has to determine whether the area of expertise that you're being proffered as an expert in is one where you have an opinion based on sufficient facts or data, would you tell the court what you mean when you say loads?
I think you and I we discussed this yesterday. I think you asked me if I thought that there were a dozen or so studies, and I said At the time, we were talking about, you were using the term prejudicial, and I said, I'm not sure if the word prejudicial appears in all of these studies, but I would guess that there are at least a dozen studies, and I would consider that a significant number on something as sort of narrow as the potentially prejudicial impact of rap music, yes.
Now, I didn't mention prejudicial impact today.
No.
I specifically said, with respect to the phrase, there are loads of empirical research on the racial aspect of rap music's impact on listeners. I wondered and wanted the court to know and ask that you tell me what you mean by loads in that sentence.
Several.
And what numerical value?
I don't have a numerical value. I would happily go to my own book or my own research and just check my bibliography, but I don't know the answer to that.
It doesn't have to be exact.
10, 12, more?
Okay. Would you say more than 20?
That are empirical? I don't know. It could be. It could be.
Okay. And this load of empirical research on the racial aspect of rap music's impact on listeners, did you mean anyone other than Adam Dunbar's work?
Absolutely, yeah.
Okay. Whose studies have you looked at that examined the racial aspect of rap music's impact on jurors?
On jurors,
Yes.
I'm only aware of a couple.
Okay. Now, a couple, I can safely say, is two, right?
2 or 3.
And those couple that you are referring to, were they both Adam Dunbar studies, or were there other people?
Other people.
Okay, who are the other people?
Stuart Fischoff, published the same year as the study I cited yesterday by Carrie Freed. I think it was even in the same journal in the same issue. And that was looking at the impact of rap lyrics on potential jurors.
And of these 2 or 3 studies that you've looked at,
Yeah.
isn't it true that neither of them involved in a single actual juror that was required to evaluate any tendered lyrics or statements of purported rappers?
It is correct that the studies that I'm citing right now did not consult or include actual jurors. I will say that the Fischoff case, though, was based upon his own experience as an expert in an actual trial.
But it did not involve any interviews with the actual jurors in that actual trial, did it?
Yeah, I don't think he'd be permitted to interview jurors in the middle of a trial.
Did you know that after a trial, anybody can talk to any juror?
Yes.
And he didn't talk to any of those jurors, did he?
I
He
don't-
didn't cite them in his study.
Let him
Right.
finish.
I don't know if he did, but correct, I don't believe he cited those if he did. If he did interview jurors, that's not reflected in that study. I agree with you.
And would you agree with me that given the nature of that study, the impact of a piece of evidence on jurors, it would be important to talk to actual jurors?
I mean, I don't think it necessarily would. I mean, jurors are our peers. And so I think if we can start to measure how people respond to whatever it is we're measuring, that's still useful. Talking to actual jurors, I mean, we're all potential jurors, or most of us. So I don't know that you would have to consult with somebody who was actually sitting in a jury in order to derive relevant, important information. I mean, that's how these studies all work.
You and I and everybody else just sitting around here, we are quite distinguishable from any of the people who would be sitting as jurors in this case, in that those people unlike everybody else, will have the unique opportunity to evaluate the evidence that is the subject, or the type of evidence that is the subject of the studies that you've relied on, in the same context and space as they will other evidence and laws given to them by a judge. Are you saying that it is your opinion, or that as an expert it is immaterial to you, it is not important to listen to circumstances like those from people who have actually evaluated lyrics in the context of other evidence and the law that the court gives it to them?
I couldn't follow your question.
I don't understand.
Hold on, wait. I couldn't follow your question, Ms. Love. It was compound, very long.
Break it apart.
Okay,
I
but
appreciate the court for telling me.
before that, though, Mr. Steele, do you have an objection?
Yes.
Basis.
Beyond the scope of a Daubert hearing. This is just maybe in front of a jury, I'd be objecting then too, but this is not a qualification.
Judge, this goes directly to the facts and data upon which he has relied in order to come to or to present to the court any body of knowledge or skill he is purported to have. If the court finds under Daubert, under 702, that his knowledge base, his body of knowledge that he is purporting to be an expert on, is based on insufficient facts or data, is not the product of reliable principles and methods, and that the applied principles used in these studies cannot be applied reliably to the facts of this case, just to broadly, sort of bullet point some of the areas that the court is to look at, then he doesn't get to come through Your Honor's gate. So the kind of data
I'm gonna just hijack you for a second, Ms. Love. If you take a look at the 702 notice that Mr. Steele filed, okay, it shows which areas he's gonna have him testify to. That would be helpful for me to kind of determine those particular areas. And, he's laid that out fairly well in his, there's A through I of what he's going to testify to. The issues you're getting to right now go to weight. I mean, and they're more appropriate for trial. But, again, if you read NUNDRA and if you read the 702 and my gatekeeping function, you're way beyond that. So I'll sustain his objection.
Thank you, Judge.
Mr. Jimenez, you need to use the restroom?
Yes, Your Honor.
All right, I'm going to let you use the restroom. We're going to go ahead and recess in place, okay? Because we haven't been out here more than about 45 minutes. So. Okay, all right. Does anybody else need to use the facilities? If anybody else needs to use the facilities, now is your time, okay? We'll just recess in place.
Just ask down to the court. We're in recess if you need the bathroom.
Oh, no, I'm okay. Thank you. Stuart, and I think he may have spelled it Stuart, and then Fischoff, so it's Fischoff, I believe. Sure. Yeah, yes, I think I got it right, though.
Here we go.
Never actually did anything on camera. Because it's always clean.
Right at you.
Actually, you're getting blocked by the monitor.
It was better yesterday when the chair was lower. It's not as comfortable, but
The judges say,
I can't see a thing. Yeah, this is the first time I've ever been in a court where I couldn't see the judge.
Mr. Steele, we have questionnaires. One of the jurors says did not have the questionnaires, so we brought in copies. Curtis has another juror.
Three would be great if you have it.
Sure.
Thank you so much. Appreciate helping.
I'm doing well. Curtis will do it. Would you like copies, Mr. Johnson?
What's that?
All right, Deb Ingram, or is everyone back, sir? Okay, all right. Let's see our lawyers. All right, okay. All right, Ms. Love, you can continue, madam.
Thank you, Judge. And sir, part of your research was based on studies done by Adam Dunbar, correct?
Yes.
And Adam Dunbar, prior to conducting his own research that you relied on, said that there was a lack of empirical research on this issue, correct?
I don't know
You don't know what?
whether he said that or not.
Do you disagree with that?
Yeah, I mean, I think there's thanks to his research, certainly, I think there is now a fairly robust body of research. He's published multiple studies.
And in fact, Dunbar conducted his studies in response to calls for more empirical research from both you and Dr. Kubrin, correct?
And others, yes.
Specifically, Dunbar was responding to calls for empirical research substantiating your work.
Substantiating my work? I'm not sure I understand.
Okay.
I think I understand. I don't think you go into a study trying to substantiate something. You formulate hypotheses and then you test them. So if you go in with the purpose of substantiating somebody's claims, I think you've compromised the scientific process.
So, Adam Dunbar does his study as he cites it in his abstract. Did you read the abstract for the article that you used?
Which article are you referring to?
Art
He's
or
written a number.
Confession?
What year was that?
Either of them. Either the first one or the one he did 10 years later that was updated.
The one that he did 10 years later, he hasn't been conducting research for 10 years.
How about this? Have you read the abstract for either of Adam Dunbar's articles called Art or Confession?
Are you saying he has two articles that are titled the same thing? I don't think that's true.
All right, then why'd you ask me which one?
You asked me if I had read the abstract for his study, and I said, which study? Because he's written multiple
The abstract
studies.
for the article Art or Confession.
I'm sure I did.
Okay. And in fact, in that article, Art or Confession, Adam Dunbar states in his abstract that he was responding to calls for empirical research substantiating your work.
Could you actually just read what it says? Because it doesn't say, quote, unquote, your work. I just would like to know what it says.
As in
Could you read
Nelson.
that? I just don't recall.
You don't recall? Okay. Now, understanding, and we'll get back to the abstract issue that you don't recall, but you are familiar with the data that Dunbar collected in the studies that he conducted that you relied on, right?
I wouldn't say I'm in detail. Again, I'm not a social scientist, so I wouldn't be parsing through the numbers. I am aware of the conclusions that he arrived at, some of them.
And some of the conclusions that you've arrived at are based on the conclusions that Adam Dunbar reached in his studies, correct?
I have definitely relied on his and other people's research to arrive at various conclusions, so yes.
So some of the conclusions that you have arrived at are based on conclusions that Dunbar has reached in his studies? Is that what you were saying yes to?
Yes, I mean, I'm saying that that's kind of how scholarship works. Your own conclusions are informed by the work of your colleagues and people who have done the work before you, so yes.
Yes, as to Mr. Dunbar.
Yes, as to Mr. Dunbar and
Okay.
everyone else, yes.
And you are therefore aware of the limitations of the data in Adam Dunbar's research and study?
I'm aware that all of his studies underwent peer review and were published, so if there were deficiencies in the data that made it unpublishable, it wouldn't have been published.
Okay. Then you are aware that he collected his data using the Amazon Mechanical Turk or MTurk platform?
Yes.
Okay. And you are aware that Adam Dunbar's experiments on the effect of rap music were based almost entirely on the responses of people who identified as white?
Yes, I believe Mechanical Turk skews white in its samples.
Okay.
Again, I'm not a social scientist, but I am somewhat familiar with Mechanical Turk.
And you are aware that some of his, or Adam Dunbar's rap experiments had as few as 4% black people, or literally 5 people who were black?
I don't recall, but that could be true.
And you are aware that none of them surveyed more than 10% black people? None of Adam Dunbar's experiments surveyed more than 10% black people. You're aware of that, right?
I think you've just made me aware of it. He does acknowledge in his studies that, again, Mechanical Turk and his sample sizes skew white. I didn't know the percentages.
Okay, and I can't testify, so it's your testimony. You didn't know that none of his experiments surveyed more than 10% black people?
I did not know that number.
Okay. You are aware that according to the 2020 census, black people make up approximately 26% of the United States population?
26% of the population, black people? No.
Are you aware
That's incorrect.
that Fulton County is made up of approximately 44% black people?
I wasn't, but black people do not comprise 26% of the population. I think it's closer to 12 or 13%.
Are you aware that Fulton County is made up of approximately 44% black people?
I am now.
So you were not?
I knew it had more black people than the overall U.S. population, yes, but I didn't know it was 44%.
Mr. Steele, you're going to have to actually say that you have an objection when you stand up, sir. Could you please do that for me? Hold on. So, sir, in the future, just if you stand, just say you have an objection so that I can recognize you, okay?
Yes, sir.
All right, so do you have an objection?
Yes. These are peer-reviewed articles. This may go to a jury. I'm not even so sure.
What's the basis of your objection?
702 is being way expanded in Dalbert. It's beyond the scope of this hearing.
Ms. Lowe, I tend to agree with him about that. Do you want to move on to something else?
Judge, the facts that I am asking questions about go to the underlying data of the information that he relies upon. And that's 702 explicitly.
Okay, but could you get to it, tie it to something? So,
I mean, I will, of course, I'll tie it to an argument, Your Honor, when we argue, but I wanted to get the witness's testimony on it. I didn't want to just argue facts that I didn't have in evidence. But I will move forward.
I think you can ask your witness whether or not he's done any of his research encompasses any of the population in Fulton County. I mean, I would think that I would probably ask him that. Might be relevant for 702.
Thank you, Judge. Sir, you are aware that the jurors in this case come from Fulton County, correct?
Yes.
And you'd agree with me that that is a pool of more than 4% of black people that will be in this jury pool.
A pool of more than what percent?
4.
Oh, I see. I don't know who's going to end up on the jury. I have no idea.
But the pool of people that includes African Americans or black people will be greater than 4%. There will be more than 4% black
You
people
have an
in the
objection,
pool.
sir?
Same objection.
I'm going to allow this one, okay?
You'd agree with me, right?
I really don't know how you formulate your jury pools. I don't know if it's off DMV records. I don't know if it's off voter rolls. I would assume that, yes, it would be higher than 4%, but I really don't know the methodology that's employed in Fulton County.
And Adam Dunbar said that he only allowed people over 18 to participate in his study for his research that you relied on, but he admitted that participants were filling out the surveys anonymously online, so he had no way to check their ages. That's significant, isn't it?
I really don't think it is. I mean, again, these are peer-reviewed studies. The Mechanical Turk has undergone all kinds of evaluation and has been found to be at least as reliable as other methods of collecting data. What you are describing as deficiencies, respectfully, I would say you do not have the qualifications to call deficiencies. It survived peer review by experts.
I'm not describing anything. I can't testify. I'm just asking you about the data that you rely on for the conclusions that you reach.
I rely on peer-reviewed data.
Okay. And Adam Dunbar stated that he only selected participants within the United States, but he also admitted that a participant could use a VPN to get around that technicality. That's significant, wouldn't you say?
No.
And Adam Dunbar's other limitations that that were part of his research is that people who have been convicted of felonies weren't excluded.
Were not excluded, I see.
Correct.
Okay.
His research potentially included people who were convicted of felons and might more heavily swing one way or the other on the topic.
I don't agree with that.
Were you aware that it included...
Hold on.
I apologize, but this is not Dr. Nielsen's research. He relied on what Dalbert says, what none of it says, peer-reviewed information.
Now sustain the objection.
Thank you, Judge. And are you aware that Adam Dunbar never spoke to an actual juror in any of his studies, in any of his peer-reviewed studies?
You know, I have the same exact, it's the same questions.
Same thing. I'm sustaining the objection.
Just one moment. Sir, have I asked you whether you personally have interviewed actual jurors?
You have not asked me.
Have you interviewed actual jurors?
Through an attorney, no, I have not, but in one or two cases I've testified in, they did poll the jury afterwards and I was given the results.
Okay, but you're aware that polling the jury just involves 3 questions. Is that your verdict?
Okay.
Is that your verdict in the jury room? Is that still your verdict,
Okay,
correct?
fair enough. No, I did not. I misused the word poll. They interviewed the jurors afterwards and asked them far more questions than that.
And you've actually watched criminal trials before, correct?
I mean, I get, yes. I mean, I've sat in this chair multiple times.
Have you watched the entirety of criminal trials where, for instance, lyrics were used as one piece of the evidence presented?
Yes.
You have?
Yes, actually, I've testified in 1 or 2 cases where I was there for the entire trial because the lyrics themselves were being charged as true threats, so there was not other evidence. The lyrics themselves were being charged as criminal.
You testified in the trial?
Yes.
So you couldn't sit through the trial and watch it?
You have an objection? What is it?
Beyond
Basis.
Same basis, beyond doubt. Ask about the rule of sequestration now. That was the last question. You know, I value your time. I value everyone's time. This is the same. We've been here, I don't know, an hour. There's no.
More than that. More. You've
Your
got,
Honor, I asked him whether or not he had watched any particular.
This is not qualifications under Daubert or 702.
It goes to the
Asking
reliability.
if Dr. Nielsen sat through a trial and was subject to the rule of sequestration.
reliability. Whether a technique can be tested, whether it's been subject to peer review and publication, the known or potential error rate for the theory or technique, the general degree of acceptance in the relevant scientific professional community, and the expert's range of experience and training. That's reliability. That's what the Supreme Court of Georgia tells me in under that are factors that the court has to weigh in addition, as it relates to reliability. But
Your Honor, that's for scientific evidence. This is non-scientific, and that one would be 24-7-702B.
I understand that, madam. I understand
Yes, Your
that.
Honor.
Okay, but under 702 still, will it help the trier of fact understand the evidence to determine the fact and issue, whether it's based upon sufficient facts or data, testimony as a product of reliable principles and methods, and the experts reliably apply the principles and methods to the facts of the case. So, and then, so what I'm going to sustain his objection, Ms. Love.
Yes, Your Honor.
But let's just move on to, and see, yeah, like you said, those are the things under 702, but I need some assistance with that.
Thank you, Judge.
Okay.
Do you intend to proffer, or is it your expectation, rather, that part of the testimony or the area of expertise that you would be speaking to would involve your assertion that prosecutors single out rap music to convict people?
Your Honor, that goes to opinion. That could be objected to at a trial. That does not go to qualifications.
Your Honor, I'm getting into
Let me
the...
finish, please.
I sustain the objection as to form.
As to form, okay, thank you, Judge, I can change it. So, in your own research, you talk a lot about prosecutors, right?
Yes,
And who you say single out rap music to convict people, right?
correct.
How many prosecutors have you actually talked to about their case?
While the case was ongoing,
Ever?
I've spoken to prosecutors before. I recall speaking with Alan Jackson, so he was a district attorney in, I believe it was Los Angeles. He's written about this, and I cite some of the things that he has written that make it clear that he is targeting or was targeting rap music. He and I have spoken about it. I've spoken with Dave Laban, who is the head of the, I think, American Prosecutors Association. I've spoken to a number of prosecutors about this issue. I can't recall if I've spoken to them about their specific cases, but I've certainly spoken with them about this issue.
Well, I appreciate that answer, but that was my question. How many have you actually talked to about their specific case?
I really don't recall. Certainly, not many, if any. I don't recall.
Is it possible that you've spoken with none?
About their individual cases, it is possible.
Now, you spoke on direct examination that part of your legal research or part of your expertise involves a book that you wrote, Rap on Trial.
Co-wrote, correct.
Thank you. And in your book, you state or claim that over the course of 10 years, you have been seeking out and documenting cases of rap on trial, correct?
Yes.
And you state that you have identified 500 cases in both state and federal courts involving, as you put it, rap on trial, correct?
Yes, we're closer to 700 now.
And you state that you found these cases through searches of legal case databases and media reporting, speaking with defense attorneys that were seeking expert assistance, correct?
All of those sources, yes. In addition, we've, with the help of defense attorneys, we've put out calls for case information on various attorney listservs. So these weren't necessarily people who were looking for expert testimony.
Okay. So I asked a specific question, and forgive me if you think that in all of that I got an answer, but my question is, in your book, you state that you found the 500 cases that you had identified in your book through searches of legal case databases and media reporting, and speaking with defense attorneys that were seeking expert assistance.
Yes, and more.
I'm sorry, since Mr. Steele was talking over you, I didn't hear you.
I said asked and answered.
Sustained.
And these 500 cases, what states were they from?
A number of states. We actually have this, our database information. We just launched our website where you can go search it anytime you want, rapontrial.org. You can go and we have individual cases by state. I don't remember exactly how many states we found cases in, but the majority for sure.
So you can't say how many cases were from each of those states, which numbers you don't remember?
If you gave me 5 minutes, I could.
Now, can you tell the court how each of these 500 cases that you relied on for your book were resolved?
I would have to go in and look at our database. We did collect outcomes for a number of cases.
So you don't know?
Off the top of my head, no.
Okay. And
I do know all of the ones I've worked on. I can tell you the outcomes for all of the ones that I've worked on.
do you know whether or not all 500 have actually resolved, is what I'm asking?
No, some are ongoing. I mean, some of these are on appeal.
And so based on what you said, you don't know how many have resolved, correct?
No, but I could get that information, I'm sure.
And do you...
Excuse me. I'm going to object on the same basis that we are far afield from Dalbert and 702 under 24-7.
Your Honor, this goes to methodology.
Excuse me, Miss. Yes. I am going to object, Your Honor, again, under Dalbert, as well as 24-7-702. We are far afield. This is outside of this motion that we're hearing today.
Your Honor, if Mr. Steele is through, this goes directly to his methodology.
All right, I'll overrule the objection. Go ahead and answer it.
Sir, you can answer the question.
Could you ask it again, please?
I sure can. So you don't know how many of those 500 cases have resolved, correct?
Off the top of my head, no.
And could you tell us how many of them went to a jury trial?
Off the top of my head, no.
Can you tell us how many of them resolved by a plea?
Off the top of my head, no. And actually, that's a tough one. That can be tough information to find, but no, of those 500, I can't tell you off the top of my head.
Can you tell the jury or the judge how many of them were dismissed?
I cannot.
Of those 500 cases you cited as the basis for your book, or at least that informed it, can you tell the court how many cases involved lyrics that were actually admitted at trial?
No. No, but that's actually that's a fair point. We're at 700 cases now, and we know that 700 is a vast undercount because if it's a plea deal, we're not going to find it in Westlaw, we're not going to find it in Lexis, and the vast majority of cases do not go to jury trials. So 700 is probably a drop in the bucket.
So if you're not able to speak about the 500 you cited in your book, then you can't tell the judge how many of the 700 cases involved lyrics that were introduced at trial either, can you?
Correct.
Okay. And you can't tell the judge how many of those 700 cases that you cited for the court resulted in a guilty versus a not guilty verdict at trial, can you?
Well, we know that the vast majority have resulted in guilty verdicts. And all of this is information that I would be happy to provide to the judge if asked. This is a massive database of information, and I don't have all of these figures committed to memory.
Okay. Well, I'm asking you now, how many resulted in a guilty versus a not guilty verdict of those cases where lyrics were introduced at trial?
Vast majority. That's all I can tell you. I don't know the numbers. But we have certainly looked at this.
Are you able to give the court any indication of what vast majority means for you, numerically?
Your Honor, Dr. Nielsen has answered this question. He said if you look at his book, there's a link. It's all published. It's been peer reviewed. We keep asking the same questions.
Well, it does go to methodology, though, so.
Not really, in my opinion. However, if you want it, just let him pull up his phone and get on the link, or let Ms. Love get on the link. She keeps asking questions that the gentleman says, I don't know it off the top of my head, but it's on my website. You can look at it. It's public information.
I'm overruled. I'm going to sustain the objection, I should say. Overrule the objection. I apologize. Go ahead.
Thank you, Your Honor. And sir, of those 700 cases that you cited to the court that you relied on as a basis for your book, how many of those cases had more evidence than just music lyrics?
Most.
Which cases, or how many cases, had only music lyrics listed as?
It would be the subset of cases that where a defendant was charged with communicating a terroristic or a true threat. That in those cases the lyrics are themselves the crime, and so again, it doesn't sound like you're actually asking me about my methods. You're asking me about my memory.
I object to the witness telling me what it sounds like to him. I would ask that the court instruct the witness to simply answer the question unless instructed otherwise by the court.
All right. Dr. Nielsen, just answer the question.
Yes, sir.
As first posed, okay?
And I'd like him to finish his answer because he was answering that question.
Yeah, you keep talking over him, Ms. Love, so you could just ease back just a little bit and let him finish, okay?
Certainly, Your Honor. And I would also point out to the court that what the witness was just stating was not in response to anything that I asked.
Well, that's why you had him answer. That's why you asked me to direct him to answer the question. So, Dr. Nielsen, if you just answer the question as posed, okay?
Yes, sir.
All right. Go ahead, sir.
So.
Wait, he has to finish his answer.
Yeah, let him. He was not responsive. Let him re-answer the question.
Yes, Your Honor.
Okay. All right. So, sir, are you ready to answer that question now?
If you wouldn't mind re-asking it, I would appreciate it.
Hang tight. We can give you the exact. Go ahead and read that back, Christina. Please.
A lot of back and forth sometimes.
sir, of those 700 cases? Is that where it starts, Christina?
Yes.
Also, it says which case or how many cases have only music lyrics, only music lyrics listed as evidence?
Were you able to hear that?
Yes, okay. The cases, right, that's where I was. The cases that were charged as true threats or terroristic threats, in those cases, the lyrics are all of the evidence, or most of the evidence, if not all of them. But I don't recall from our database how many there were. We know that these true threats prosecutions are a smaller subset of our overall data set.
And did you just say you don't know how many of the 700 cases that you relied upon for your book are in fact true threat cases?
Off the top of my head, no, but again, that's something I could get the answer to pretty easily.
All right. In the cases where lyrics were introduced, have you spoken with any of the jurors in these cases to discuss whether the lyrics played a role in their decision?
Asked and
Now,
answered.
that's been asked and answered. I'll sustain the question. Sustain the objection.
And Your Honor, I am speaking, and thank you, Your Honor, of course.
Why are you thanking me for ruling?
Because, Your Honor, I appreciate the court taking the time
Adam,
to...
it just sucks up record space that we don't need,
Yes,
okay?
Your Honor.
All right. I know that you're a consummate professional, so, and you won't take anything personally to me or anybody else, but so it's not necessary, okay? Okay.
I really do want to thank you, but I'm going to go on.
You can thank me this time, okay?
Okay.
And,
Thank you, Judge.
Okay, all right, okay.
Of those 700 cases that you relied on as a basis for your book, did you believe that it was not important to speak with any of the prosecutors, judges, or jurors in those cases?
To clarify, it was 500 that informed the book, not 700. We've collected another 200 since the book was published.
Thank you for that clarification.
I actually never thought that a judge would talk to me about that. I would be happy to speak with judges about it. I certainly have informally. In terms of jurors, I think I already answered that. Attorneys have in a couple of cases interviewed jurors after the fact and asked them precisely what you're asking, which is what was the role of rap lyrics, what was the role of Dr. Nielsen's testimony. That I actually cite that in my most recent peer-reviewed article.
Now, as to your qualifications, you did your graduate studies in the South, correct? You didn't do your graduate studies in the South, correct?
Only my undergrad.
Okay. And when you say on your undergrad?
Yes, I went to the University of Virginia, which is in the South.
Some might not consider it the South, but that's okay. You didn't do your graduate work in the United States, did you?
No.
And you mentioned that you got your master's in London, is that right?
Yes.
And you got your PhD there as well, right?
In Sheffield, still the UK.
Okay. And you got your master's in 2001?
Yes.
And your PhD in 2011?
That is correct.
And you were in the UK that entire time?
I was not, no.
You were not?
No.
Okay. How much time did you spend in the UK?
I spent a year and a half in London getting my master's degree, but then I lived in the South, if you count Virginia as the South, and went back and forth to the UK, but my primary residence was actually in Washington, D.C., and I worked in Virginia.
So you spent the majority of your adult life outside. You've never lived in Georgia, correct?
That's correct.
Okay. And you're not from Georgia, right?
That's correct.
And you haven't talked to anyone from Georgia about the topic that you are offering expert testimony on, have you?
I most certainly have.
Okay. And so, have you interviewed people from Georgia for the studies that you've now published on?
The studies that I've published on.
For all of what you've listed in your resume. Let's see. Under scholarship and peer-reviewed articles,
Okay.
you've not interviewed anyone from Georgia on the topic of,
I have.
right,
I'm sorry.
of the impact of lyrics in a jury trial who have actually served on a jury, have you?
Oh. So I understand, you're asking if I have spoken to anybody from Georgia about the issue of rap lyrics being used in criminal cases who also served on a jury in Georgia.
Well, essentially,
And are you asking if it was somebody who served on a jury in a case involving rap lyrics, or who has just
Yes.
been a juror once? So no, I do not believe I have ever
Okay, Dr. Gibson. Under 401, 24, 401, and 402, this is irrelevant.
Well, it's relevant under the,
Under nothing.
under 702 in terms of the issue of scientific facts or data and reliable principles.
Your Honor, whether Dr. Nielsen has spoken with a juror from Georgia, I mean, are we that myopic here? This man is an internationally known expert on this field. This is, respectfully, this is outrageous to treat him like this, to come to Georgia and treat him like this. None of these questions are relevant to doubt. I object under relevance.
All right, Mr. Steele, and this is the rigor that is required by our legislature in 702 under the renewed standard of Daubert and under our legislative changes. It was a lot easier to qualify experts prior to July of last year. It's just that our case law seems to indicate that that experts have to be pre-qualified, and this is the process. So I don't believe that there's any intent to show any disrespect to your witness.
Respect not.
Yeah, I mean, but you know, this is just part of the examination. You're doing your job, Miss Love is doing hers. I'll do mine. But you know, let's just stick to the issues, okay?
That's okay.
All right.
That would be great.
All right.
and sir, you've come to talk to people who are necessarily from or live in Fulton County, and you do understand that Mr. Steele's client, Mr. Williams, is in fact from this county, don't you?
I knew he was from Atlanta.
From Fulton County. Atlanta's
Okay.
in Fulton County. You knew that, right?
Yeah, I thought that DeKalb was, part of Atlanta was in DeKalb also.
And do you understand that this jury may consist of people who essentially grew up here and made Mr. Steele's client the person that he is today?
Your Honor,
What's the base for your objection, sir?
the jurors come from everywhere.
What's the basis for your objection?
This has nothing at all, respectfully, to do with any reason why Dr. Nielsen is being qualified under Daubert.
All right, I sustain the objection to this question.
Thanks, Judge. I just have,
Remember, no
One more.
need to thank me, okay?
you're making it hard for me, but I'm going to try. And sir, it is your testimony here today and yesterday that you want to tell Fulton County citizens how to listen to this defendant's music, who grew up and made his music here in Fulton County.
That's so not part of his testimony, Your Honor. I am objecting. And it's opinion. It doesn't go to qualifications. If that was a trial and that question came up and the court found it objectionable, it would sustain the objection.
I sustain the objection.
Just 1 second, Your Honor.
Yes, ma'am.
Thank you, Judge. That's all I have for now.
You're welcome, madam. All right, Mr. Steele, anything else, sir?
Very briefly, yes. Dr. Nielsen, I've asked this honorable court to qualify you as an expert under African American literature, music, popular culture, with a particular focus on hip hop, and then the subparts, because I was trying to be fair to everyone, or transparent, A through I, and I don't know if you know what A through I is, but it's everything we went through. Do you understand that?
Yes.
Okay. How did you formulate and base your opinion on history of hip-hop relationship to gang bonds? It's A, Your Honor, in the notice of expert testimony filed February 2, 2023.
My own research and the peer-reviewed research of a number of my colleagues across the academy.
Have you then, based upon that subset of African-American literature, music, popular culture with a particular focus on hip-hop, have you been published, peer-reviewed?
Multiple times.
Okay. On B, as in Barry, the artistic traditions that preceded hip-hop, have you, what basis have you done, and what have you done to be qualified as that subset of the African-American literature, music, popular culture with a particular focus on hip-hop?
I have published on that as well, and I have relied on the peer-reviewed work of my colleagues across the academy.
And then C, as in Colette, the industry expectations for upcoming rap artists, the demands for gangster rap. It's my same question. I'm going to ask the same question for all of them.
And I'm probably going to give you the same answer for each one, too, which is I've published on this, and I've relied on the peer-reviewed research of my colleagues across the academy, as well as my own, my research has also included interviews with people within the industry.
And have your publications been peer-reviewed, like you said earlier, double-blind?
Most were double-blind. All of the ones that I've listed as peer-reviewed are. With the exception, I think I noted that one of the book chapter I included in there, I'm just not aware of what peer review process they used, but I believe it was peer-reviewed.
Okay. Everything's peer-reviewed is the point.
Yes.
D, as in David, hip-hop is a global multi-billion-dollar industry, legitimate pathway for success of young men and women in urban communities. Same.
Relied on my own research, the peer-reviewed research of my colleagues, and industry publications as well.
And your work has been peer-reviewed?
Yes.
E, as in Aaron, artistic conventions of rap music, particularly lyrical and poetic. Same question.
Same answer.
F, as in Fox, the prejudicial nature of rap music.
Same answer.
G as in Goldfeder, the history of policing and prosecution of rap music or hip hop.
Same answer.
And then H as in Happy, rap is the only fictional form, musical or otherwise, targeted in the courts, even as other forms have the same amount or more violence.
That's based on, I've published on that, and that's based upon my own research as well as the research of others. I can't tell you for sure whether or not, aside from my own peer-reviewed work, if there's other peer-reviewed work on what fictional forms have been used or not. I know, though, that it has been tested by a team related to the New York Times.
And has your work on that been peer-reviewed?
It has.
And then considers analogous forms of entertainment. You gave us a wrestling example.
I did.
Okay. All of this subsets of the African-American literature, music, and popular culture, particular focus on hip-hop, A through I, have you been qualified and testified under Daubert in other courts and accepted as an expert?
Absolutely.
Have you ever not been accepted as an expert in any of these fields?
No. Well, I should say I don't recall every case what I was offered, what expertise how it was described, but I have certainly in every case testified to all of these, in many cases testified to all of these, and I've never not been qualified.
And now I was going to make it easier. Have you ever been offered as an expert in any of these fields and a court has found that you are not qualified to give testimony?
No.
All right. Have you been referred to as, and these are my words, but an expert's experts?
Yeah, yes, I've been called the go-to national consultant.
Object as to this, it's
Basis.
irrelevant. The expert's expert is hearsay and irrelevant. Hearsay and irrelevant.
Hearsay is admissible at a Daubert hearing, pre-trial, A, and B. It goes to its qualifications. This is what he's been recognized as.
I overrule the objection. Go ahead.
Yes, I believe I was characterized by the Los Angeles Times as the go-to national consultant on this issue, by the BBC as the foremost authority. Yes.
And everything that you've told the Honorable Judge Glanville in this courtroom on your oath is relied upon on peer-reviewed articles, including your own.
Peer-reviewed articles among other sources as well.
I was going to say research, books, publications, the whole gamut. That's what you relied upon.
Yes, interviews as well, all of it.
You also teach these topics. Is that true?
Regularly.
And this is how you've devoted your career. Is that fair?
I think that is fair, certainly for the last decade.
And you also have your own education in this field.
Yes.
Thank you, Your Honor.
Anything, Madam?
Briefly.
All right.
Sir, today you just testified on redirect that you have been qualified specifically as an expert as to each one of these listed subject matters that Mr. Steele read out to you. Yet yesterday you said you did not know what areas you have been qualified as an expert in. Now, are you here today telling the court that you specifically have been qualified as an expert in each of these specific areas?
I'm not sure you heard my response to Mr. Steele. What I said was I'm not exactly sure what the description of how I was introduced as an expert was, but I have testified to all of those A through I in a number of cases, number of trials.
Okay, but his question was, have you been qualified as an expert in each of these areas, A through I? And I did hear your response to the finished question, and you said yes. Is that now not your answer?
My answer is that because it's my assumption that because I was permitted to testify in a trial on all of those topics, that my assumption was that the court viewed me as qualified to talk about them. So yes.
In trials, you have been qualified as an expert in each of these areas, is what you're saying? Because you said trials.
Hold on. What's the basis for your objection? Ask and answer? All right, I'm sustaining the objection. That's the point.
And As to H, would you please repeat for me the data that you relied on, or the information you said you relied on for your opinions about rap as the only fictional form, musical or otherwise, targeted in the courts?
That was based on my own research, which is peer-reviewed and substantiated, at least in part, by an analysis conducted by a team associated with the New York Times.
And the name of that article that you are relying on as the basis for your expertise in the area of rap as the only fictional form targeted in the courts is what? What's the name of that article?
I believe I say that in my expert or advocate, the role of the expert witness when rap is on trial. We also say this in the book repeatedly. And I can also, I'd be happy to refer you to the data-driven New York Times article where, I think I mentioned this yesterday, where researchers looked back to 1950 and could only find 4 cases of fictional forms that were not rap music introduced like this.
Okay. And when you used the word targeted in the courts,
Actually, my words, Your Honor, I apologize.
Your Honor, this witness just stated that he's formed, or he's formed this opinion as
Say
to.
again, hold on.
I'll withdraw. I mean, it's
Okay.
my plea, I just wanted to correct it.
And Your Honor, Mr. Steele will allow me to ask.
Yes, ma'am.
Thank you. When you say in your written articles or work that rap is the only fictional form targeted in the courts, and given that it's your work that you rely on for this opinion, what can you tell the court what it is that you mean by targeted in the courts?
Targeted, I should say targeted in the courts. I want to make sure we say that, not by the courts. And what I mean is that no other fictional form is used this way, is treated as literal or autobiography and used to establish somebody's guilt. We found hundreds of instances, whereas with other forms, we've got 4 over the course of about 75 years. All 4 were either reversed or dismissed. To me, that qualifies as targeted.
Thank you, Your Honor. That's all that I have for now.
All right, thank you.
What did she say? What did she say?
I'm going to take a brief recess, just a minute. Come back and let you know where we are. All right? Hey, Wes, do we have any papers?
Dr. Nielsen, can I get you to step outside, please, for a second?
Yes, sir.
All right, councils. Having considered the matter of the testimony of Dr. Eric Nielsen under the court's gatekeeping function as required under Daubert and 702 as required by the
Your Honor, will we be allowed to argue, please, prior to the court?
I don't really need any argument. Don't really need any argument. I mean, we've heard the same issues about 5 times now, so I really don't need any more assistance with this.
Your Honor, I understand, and I am asking for the court's indulgence. There were a couple of points that we would beg the court's indulgence to be allowed to make. We will not belabor it. We will be very short, 15 minutes, 10 minutes, maybe we can get it. 10 minutes, Judge?
I have other things I have to take care of. I told you my role as a chief judge. I have other things I have to do, unrelated your case.
And Your Honor, when we were speaking earlier, Mr. Steele was allowed to make an argument that I said is an argument to the court. We would just ask
Madam,
for the opportunity to speak a little bit.
I'm duty bound, but I'm telling you, I don't need any more information. I'm telling you that. But if you want to go ahead and assert that, I will recess right now and come back after lunch. I'll come back after lunch. I mean,
Very good, Judge.
No, because I don't want it to ever be said that I cut off your argument. That I cut off your argument for you to go ahead and do that. So
I'm okay.
let me do that.
Fine with the court.
Let me do that. Madam and sir, I will go ahead and, given that I do have some other unrelated business, as I mentioned, one, it'd be a good time, and since lunch is here right now, is that correct, Deputy Ingram?
Not yet.
Okay, well, I'm going to go ahead and let them, since I have some other business that starts at 12:45, but it will, I will be ready and to come back for, let's just say 2 o'clock, and then Ms. Love, you can have your 10 minutes, okay?
Your Honor, and it would be Ms. Weintraub. I was trying to let the court, it would be someone shorter than me, so we were ready. We don't oppose the court's.
No, she can, I mean, look, I'll let you argue to your extent. Mr. Steele, will you require any arguments, sir?
No.
Okay, all right. Okay, with that, let me go ahead and I have some other unrelated, let me go ahead and take up this while we're here right now, since I have all of you here. Ms. Monkelch did, in fact, give the court some documents on Juror 302. If you want to go ahead and turn your materials that we have on selection. .302. .302 now has provided, we examined 302 some time ago, I believe in our first group of folks, and she is currently with child. I now have a document from her physician indicating that from 4/24/23 to 1/8/24, requesting that she not participate in any jury duty, and due to complications requiring treatment and monthly evaluation, she is considered to be in high-risk pregnancy and hyperemesis gravidum, which is spelled HEPEREMESIS, and then the second word is GRAVIDARUM. Counsels, I'm going to let you take a look at this if you'd like to. but I would ask your permission to excuse her for medical hardship.
Your Honor, the state has no objection to that.
On behalf of the defense and based on the court's representations, we have no objection.
Okay. Ms. Boncallis, we'll go ahead and excuse juror 302, please, madam.
Thank you, Your Honor.
You can contact her and let her know she's been excused, okay?
Thank you.
All right, thank you, madam. And I will include her documents as the next court exhibit in order. Okay, all right, so we're gonna recess for lunch at this point in time, councils and interested parties, and we will be back in pocket for 2 o'clock to continue just with final argument in the court's ruling on this particular issue, okay?
May I inquire of the court one moment?
What's your inquiry, sir?
Dr. Nielsen, I was told, he can take flights every hour, but he has a flight at 2:30. Is there any way, if the Honorable Court would allow him to be driven to the airport now and then make his flight? And if not...
Sir, whatever you, state have any objection?
Oh, no, Your Honor.
No, he can return.
Thank you.
Okay, and we can just let him, if you'll call him back in, I'll just excuse him formally, okay?
They said he's coming in. Thank you.
Dr. Nielsen, I have it on good authority that you have a flight you need to catch?
Yes, sir.
All right, sir, I'm going to go ahead and release you formally at this point in time. Just ask you don't discuss your testimony with anybody except the attorneys in this case, okay? And we will talk with you at a later time in these proceedings, all right? Okay, appropriate. All right, take care, sir.
Your Honor, just
Mr.
one
Sharp?
more thing briefly. Due to a family obligation, I was hoping to be excused for this afternoon.
Hope's not a strategy. What plans have you made?
Sir?
I said hope is not a strategy. What plans have you made in order for you to deal with this particular
I've
issue?
spoken to my client and Mr. Botts, and they have assured me that Mr. Botts will hold the fort down, and my client agrees.
Okay, Mr. Botts, are you otherwise available?
I guess I am now.
Does your client have any issues, sir?
You don't want to hear them, but I think he's all right.
Are you okay, sir, with, okay, all right. All right, be well. Okay, take
Thank you,
care.
Your Honor.
All right,
I'll see you tomorrow morning.
okay. Remember, tomorrow morning, we will be on the 7th floor, sir.
Yes, sir.
Okay, all right.
You want to tell him the time now? I'm taking over.
All right, we will go ahead and recess, as mentioned, and I'll see you all back at 2 o'clock, and we'll conclude these proceedings at that point in time after argument, all right? Okay, we're in recess.
Reset.
Everybody's here.
Jack, you good, man?
Remain seated, court come to order.
All right, ladies and gentlemen, please be seated. All right, Deputy Ingram, do we have everybody present, sir?
Yes, sir, Madam President.
All right, lawyers, let's see. Is anybody missing or your colleagues you don't see? Okay, all right. All right, Ms. Weintraub.
Your Honor, it's never fun to argue when the judge has indicated that he made up his mind, but
No, I mean, no, I want you to have, listen, your ability to put in front of me what you think is important for me to decide my issues as the gatekeeper, okay?
thank you, Your Honor. Thank you, Your Honor. But this will be quick. Your Honor, what we've tried to show today through cross-examination is that this witness's proposed testimony does not meet the minimum threshold for Daubert. We don't even get to the factors. If the witness's testimony does not meet that precondition of admissibility, that it will assist the jury with understanding the issues or determining a fact in the case. And the citation is U.S. v. Williams, 865 F. 3rd, 1328, 11th Circuit, 2017. The court recognized, as many other circuits have, as a precondition to admissibility, Rule 702 requires a valid connection to the pertinent inquiry. And 702 also recognizes that the testimony must assist the trier of fact. And that's something that the defendant has to prove as well. The burden is on the defendant to prove that the testimony will assist the jury. And that has not happened here, Your Honor. In fact, there has been no testimony whatsoever that jurors don't understand the lyrics. There's no testimony that any of the lyrics that Mr. Williams has written or performed are in any way beyond the understanding of the average juror, and especially here in Fulton County. And that's what the court is supposed to consider, how a Fulton County juror would respond. There have been plenty of cases where courts have ruled one way or another on the admissibility of experts in this field. We are not putting those in front of the court because this is entirely the court's discretion as gatekeeper, especially not when looking at the threshold question. Your Honor, people obviously love music. They listen to it, buy it, quote it, copy it, write it, and think about it. Hip hop in particular, they've been doing it for a very long time. If we listen to Dr. Nielsen's testimony as far back as when white people were enslaving black people, there were some early elements of this. And the very reason that people buy, listen to, and enjoy music is because they understand it and because they can relate to it. The potential jurors in Fulton County who have never heard, even those who have never heard Mr. Williams' music, can understand it without assistance. The defense wants to put Dr. Nielsen in front of the jury as an expert for the very purpose of showing that the music is more complicated. And that is confusing the jury. The question is not whether something can be more complicated. It's whether the jury needs an explanation. That is precisely the kind of testimony the court is supposed to exercise its gatekeeper function and keep out. The second reason that the court should preclude Dr. Nielsen's testimony is because it's based on biased, flawed, and above all, experimental research. Dr. Dunbar himself refers to himself as a pioneer in the field, and it is indeed experimental research. And we are not saying, Your Honor, that Dr. Dunbar or Dr. Nielsen are not qualified to publish. What we're saying is that there's more than that that's required under Daubert. Peer review is certainly something the court can consider, but the court is above the peers. Daubert requires that the court consider whether the underlying facts and data are sufficient, whether they're reliable, whether the principles and methods are reliable. The gatekeeper responsibility of reviewing this methodology itself, the gatekeeper has the responsibility to review the methodology itself and to judge the sufficiency in itself. And Your Honor, I would like to point to one quote from Corwin versus, quote this wrong one, from Hendricks versus Evenflow, 609 F 3rd, 1183. And this is an 11th Circuit case. Your Honor, in Hendricks, the court stated, or quoted actually another 11th Circuit case, stating, "The courtroom is not the place for scientific guesswork, even of the inspired sort. Law lags science. It does not lead it." And what that comes down to in this case, Your Honor, is the data used in Dr. Dunbar's study, a study that was based on anonymous participants reporting online, only a handful of which identified as Black. They weren't verifiable as human beings, much less Americans. Computers could have been responding to his survey and collecting money doing so. They read stories and rendered verdicts. No actual jurors, no real evidence, no courtroom, no attorneys, no judges. And we'd like to think that all of us in the courtroom matter, just a little bit. Perhaps most importantly, Your Honor, there was no deliberation. That's the bottom line. Jurors sometimes change their minds. Sometimes they don't. By deliberation, the Constitution or the founders have determined that it matters. And that study is exactly the type of data that Daubert tells the court to exercise its discretion and screen out. The court should screen it out here. In Corwin versus Walt Disney Company, 475 F 3rd, 1239, the 11th Circuit stated that trial courts are charged with screening out experts whose methods are untrustworthy or whose expertise is irrelevant to the issue at hand. There's a reason why, as Dr. Nielsen testified, hip-hop has become extremely popular and a lucrative career path for young individuals and aspiring rappers. It's relatable, even to those who haven't lived that same experience. Finally, Your Honor, there's a very real danger that admitting Dr. Nielsen's testimony increases that risk of confusing the jury, because it tells the jurors that the lyrics that they read and understand are not really understandable, except through the help of an expert. Your Honor, the last thought I just want to put before the court is that this can be comparable to a common object used in court. Could an expert in armory tell jurors that something that they didn't know about an antique knife used in a stabbing? Certainly. They could probably talk about the history of it in depth. But would that assist the jurors in determining whether someone had been stabbed? In some cases it might, but in most cases my guess is it probably wouldn't. And the expert shouldn't be allowed to testify because of the danger of confusing the jury about something they already know. Thank you so much for your indulgence, Your Honor.
No problem, no problem. Mr. Steele, anything, sir?
No, sir.
Go ahead. No, I mean, if you have something you'd like to proffer, that'd be fine.
Submit it.
Okay, council's interested parties, this court is holding a pre-admission hearing pursuant to OCGA 24-7-702 to determine the admissibility of the testimony from the defense proffered expert, Dr. Eric Nielsen. And the defense has asked this court to qualify Dr. Nielsen as an expert in African American culture, literature, history, and music, and specifically in Mr. Steele's notice of expert testimony, it further delineates that he would be qualified to testify, or ask this court to qualify for him to testify as 1, the history of hip-hop relationship to gang violence, 2, the artistic traditions that precede hip-hop, for example, slave spirituals, blues, jazz, urban fiction, 3, the industry expectations for upcoming rap artists, the demand for gangster rap, 4, hip-hop is a global multi-billion-dollar industry, a legitimate pathway to success for young men and women in urban communities. 5, artistic conventions of rap music, particularly lyrical, poetic. 6 is the prejudicial nature of rap music. Loads of empirical research on the racial aspect of impact on its listeners. 7, the history of policing and prosecution of rap music, hip-hop, for example, 2 Live Crew, Ice-T, NWA. 8, rap is the only fictional form, music or otherwise, targeted in the courts, even as other genres have the same amount or more violence. And 9, consider analogous forms of entertainment. Those are the bases that Mr. Steele has proffered this particular expert to testify in this particular trial. This testimony from Dr. Nielsen has revealed that he has, in fact, been previously qualified as an expert in some areas in other proceedings, to include Fulton County. So I've heard evidence, testimony, and argument from all parties, and I will make certain findings before I announce my ruling, but this is pursuant to OCGA 24-7-702B. So as we all know, on July the 1st of 2022, Georgia's evidence code was amended to apply the tenets outlined in Daubert versus Merrill Dow Pharmaceuticals, 509 U.S. 597, 1993, to criminal cases in the state. Formerly, expert witnesses in the state were governed by the provisions of OCGA 24-7-707. However, as of July 1st of 2022, the rules of OCGA 24-7-702, mirroring the requirements in Daubert, now apply. OCGA 24-7-702 Bravo provides a witness who is qualified as an expert by knowledge, skill, or experience or education may testify in the form of an opinion or otherwise if, 1, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact in issue. 2, the testimony is based on sufficient facts or data. 3, the testimony is the product of reliable principles and methods. And 4, the expert has reliably applied the principles and methods to the facts of the case. And in particular, in Nundra versus the state, decided 21 March of 2023, our Supreme Court has indicated that under the Daubert, or 24-7-702, under that standard, a trial court must evaluate the reliability of the expert's proffered testimony. Proper considerations include whether a theory or technique can be tested, whether it's been subject to peer review and publication, the known potential of error for the theory or technique, the general degree of acceptance in the relevant scientific or professional community, and the expert's range of experience and training, citing Smith versus the Smith versus state, 315 Georgia 287 pinpoint 300, quoting HNTB Georgia Inc. and Hamilton versus Hamilton King 287 Georgia 641 pinpoint 642. So as we all know, the Harper standard doesn't apply to cases tried after July the 1st of 2022. So, in considering how to interpret Daubert, the 11th Circuit provides guidance for applying for the application of Daubert. United States versus Fraser, 387 F. 3rd 1244, 11th Circuit, 2004. The 11th Circuit explained that the witness qualifies as an expert may testify in the form of opinion, as in OCGA 24-7-702. Testimony is based on sufficient facts or data. The testimony is a product of reliable principles and methods, and the witnesses applied those principles and methods reliably to the facts of this case, or the case. The court must perform a gatekeeping function concerning the admissibility of expert scientific and technical evidence. To determine whether expert testimony is admissible, this court must consider: 1, the expert is qualified to testify competently regarding the matters he intends to address. So we've already addressed which things Dr. Nielsen intends to address. 2, the methodology by which the expert reaches his conclusions is sufficiently reliable as determined by the sort of inquiry mandated in Daubert. I've studied the factors our Supreme Court in Nundra says that we can consider as trial courts and practitioners. And then the testimony assists the trier of fact through the application of scientific, technical, or other specialized expertise to understand the evidence or determine a fact and issue. Citing, or I should say, looking at City of Tuscaloosa versus Harcross, that's HARCROS Chemicals, Inc., at 158 F 3rd, 584 at pinpoint 580, I should say at 56, 11th Circuit, 1998. Daubert 509 at US at 589. The proponent of expert testimony always bears the burden to show his expert is qualified to testify competently regarding the matters he intends to address, or she. The methodology which the expert reaches his or her conclusions is sufficiently reliable, and the testimony assists the trier of fact. In this particular case, the defense, through testimony as well as the CV of Dr. Nielsen in particular, the court is of the opinion that Dr. Nielsen's education, his teaching experience, his scholarship would certainly allow him to testify about the following. And these are the categories the court will permit him to testify as to, and I'll explain the other ones I will not permit him to testify as to. This court will allow him and authorize him, based upon his testimony and his CV, the history of hip-hop, relationship to gang violence, the artistic traditions that precede hip-hop, slave spirituals, blues, jazz, urban fiction. 3, the industry's expectations for upcoming rap artists, demand for gangster rap. 4, hip-hop is a global multi-billion-dollar industry, a legitimate pathway to success for young women and men in urban communities. 5, artistic conventions of rap music, particularly lyrical and poetic. The court is of the opinion that given that this particular testimony, I do have some questions about, I don't believe that it will in fact assist the trier of fact to understand the evidence or determine a fact and issue in the following categories. The prejudicial nature of rap music, empirical research on the racial aspect and its impact on listeners, the history of policing and prosecution of rap music, hip-hop. Rap is the only fictional form, music or otherwise, targeted in the courts, even as other genres have the same amount or more of violence, and analogous forms of entertainment. These particular subparts that that Mr. Steele wishes Dr. Nielsen to testify, the court finds that in particular that does not, at this point, they do not assist the jury. In particular, the presidential nature of rap music, the court will make a determination as to prejudice and balancing under 403. So F will not be, I will not permit him to testify about that as of yet. The history of policing and prosecution of rap music, I don't believe that to be relevant, and that could certainly confuse or prejudice the jury. Rap is the only fictional form, music or otherwise, not relevant. It inserts prejudice and bias, and as related to other forms of entertainment, the court will not permit that particular testimony as of yet. So, for those reasons, now, so I will permit his testimony about the aforementioned things that he is, in fact, qualified, and I will certify him as an expert in that particular area. His testimony is limited. Now, Mr. Steele, if the state opens the door as to these other areas, then I will revisit those particular things that I have excluded for the time being. So, but as of right now, we'll tell Dr. Nielsen those are the areas that I'll preliminarily qualify him in, okay?
Do it. Yes, sir. Understood.
Okay. Mr. Steele, if you'll prepare a suitable order, let Ms. Weintraub and Ms. Love have a look at that. And if you could get that to me, today is the 27th of April. If you could get that to me by the 19th of May, would that give you enough time, sir?
Of course.
All right. Okay, so that is the court's ruling for the aforementioned reasons. I owe you a ruling on Dr. Dunbar, but as I said, I'm going to reserve ruling on his particular testimony. I've got a little bit more of thought I need to kind of think about that, and I'll let you know whether or not I'm in a position earlier to make any decisions even before I hear some of the statements that he's being asked to opine on. So I'll let you all know if I'm in a position earlier to do so. Okay? All right. Anything further, counsels, as it relates to the testimony of Dr. Nielsen?
Not on behalf of Mr. Williams.
And on behalf of the state?
No, Your Honor. Thank you.
Okay. All right. Okay, let's turn our attentions toward tomorrow, okay? Just 1 second. Okay, so tomorrow we will be entertaining councils. Group 6. So I'll need you to be up in 8F, prepared to come to 7 once Captain Kendall and her teammates are ready. Then you'll be invited into that space to with your clients to get settled, and we'll go through the aspects of reading of general orientation to that particular panel, as well as reading of the indictment. And I think that we should be able to complete our process if we get started. And I would ask you all's indulgence to really, if you could get here as early as you can so we can go ahead and get started. And because as you all know, the reading of the indictment takes 3 hours and 40 minutes or thereabouts. So, and I have to take regular breaks. So we usually do about 1 hour and 15 a clip. So the earlier we can get started, the better off it will be. And I believe the last time we had the best time, and we actually got out right a little before 5 o'clock or thereabouts. So I would ask your indulgence in that and your assistance with that. And as mentioned earlier, I will in fact educate this particular set of jurors on hardships and the documents they are supposed to bring in order to make our particular assessment even easier, like we've done the past couple of groupings. So, what are your questions at this point in time?
What time did the court?
Your Honor, what time did the court tell us to be there? 9?
If you all would be, I would say, is Captain Kendall around? Hey, Deputy Ingram, can you, is Captain Kendall here today?
No. She's on vacation.
Who's coordinating the setup? Who's coordinating the setup?
Say that again, Judge.
Who's coordinating the setup for tomorrow?
I will.
Okay, so you're gonna start moving, General Service is gonna start moving things upstairs and everything else?
Yeah, 7. 7 a.m.
When are they gonna do it?
7 a.m.
7 a.m., okay. So, thank you.
Yeah, so let's find out what. He will. Yeah, he'll be there. I think they must all in inside the building. So we'll start moving. Then confirm with Mr. Wilson. I think they're looking at the same thing. My deputies are being roll call at 7:30 upstairs on the second floor.
I'll tell you what time we usually have.
Okay, what time would you like to start? I need to probably be here for 8:15. The deputy attorneys is there. They will be in late. We're gonna get there quick. Not like that, 8:30. Okay, sounds good. Okay.
Hey, Lieutenant?
Yes, Judge. Yes, 404. Yes.
It's showing 407.
984 8101.
8101.
If they can't, they come out here, I'll just open.
Lieutenant Walker. Okay. She is the point of contact. Where you are supposed to do.
It's fine, Judge.
You started mine.
She's gonna text you right now, so she'll have you.
Okay, sounds good. Okay.
All right, thanks, everyone, appreciate it.
Thank you, Judge.
Ms. Love, to your question, this pertains to everyone. 8:30 in courtroom 8F, my courtroom, okay? Now, please get here on time and be here early because as you know, it's a staged procedure, and if we're waiting on folks, we will not be able to kind of get started. So please, as much as you can, be here as early as you can, especially for tomorrow, since we have our citizenry that we have to kind of entertain, okay? Yes, sir. All right, so 8F tomorrow. All right, by 8:30. All right, okay. Any other ministerial questions of me?
Not this stage, thank you.
Mr. Botts? That will be determinative on a couple of things. I believe that Ms. Von Kelch, are you doing questionnaires and hardships, identifying people for hardships on Monday, Tuesday, and Wednesday? Oh, that's right. She's not here, she's upstairs. I'll have to coordinate that with her, but I should be able to give you some particular definite answer on that, Mr. Botts, tomorrow. But I think it's going to be Monday the 5th, Tuesday the 6th, and Monday the 1st, Tuesday the 2nd, Wednesday the 3rd. So I'll give you an exact time on that, okay? Yes. Okay, probably tomorrow, once Ms. Von Kelch is here, and if I forget, please remind me. All right, somebody else have any other inquiry? Yes, sir.
Your Honor, just as a reminder, we spoke at your bench maybe a week and a half ago.
Yes, sir.
With the court's still permission, Mr. Williams has agreed, Ms. Adams has graciously agreed. I was leaving tonight to go see my daughter. I would not be here then tomorrow for the jury, and then I would return. The plane lands at 7:35 on Monday, and I plan to then, get deplane, clear customs, and then come to your Honorable Court by noon, the latest.
I believe that as long as Mr. Adams and your client, Mr. Williams, are in concurrence, I don't have any issue with that.
Thank you,
I wish you all the best, safe travels.
Thank you very much.
Mr. Williams, you okay with that, sir?
Yes, sir.
Okay, all right. Okay, anybody else?
Yes, Your Honor. What's your anticipated start time tomorrow? I know we're going to be here.
As soon as you all get here and everybody gets situated, okay? Because everybody's been late as of the last couple of days, and we can't start until until I've accounted for all of you, all 13 of you. So if the sooner you get here, that's why I'm saying be here at 8:30. Lieutenant Walker has indicated to me that we can have your clients in pocket at 8:30 because they get over here fairly early. So if they're already situated, and then we can bring you down once everybody's kind of situated, then that will help out things. So, Mr. Matthews, to your point, I'd really like to get started before 9:30. But as anything, that's aspirational. But if you all get here at 8:30, and I can account for all of you, then I believe we could start really early and get at least an hour and 15 or possibly a little bit more played before the noontime hour for lunch, okay? All right. Anybody else? All right. Just to forecast a couple other things. Mr. Johnson, you owe me your paper tomorrow by noon, okay? So just a reminder, it hadn't fallen off my radar. And then Misty Williams, I'm still on for 1 May at 1 p.m. to hold your motion.
Thank you, Your Honor.
Okay. Have you filed your subpoenas and they've been returned and filed with the court?
I can do that today.
All right. Then I believe that we'll be ready. Okay, all right, unless there's anything else, we will be in recess until tomorrow morning. Like I said, I'll see everybody at 8:30 in my courtroom in 8F, and then we'll get started as close to we can around 9 o'clock. All right, we're in recess. Thank you. You're welcome, madam.